welcome our panelists and our individuals that we're going to hear from today. This meeting of the Washington Advisory Committee to the U.S. Commission on Civil Rights shall come to order. For the benefit of the public who have joined us today, I will introduce my colleagues and myself. I'm Brian Screener. I am the vice chair of the committee. Our chair, Alexis, was not able to join us today, so I am privileged to be sitting in her stead. Members of the committee present here today are Kimberly Ambrose, is her name, Tony Benangus, Judith Endigen, I think she's on.
Yep, I'm on.
Great. Andrew Kaufman. Yeah, I see his name is muted. Right? Zenith Nider, she's here and muted. Eric Schnapper, he is here. David DeWolf just joined us.
Here.
Great. And am I missing anybody else who I do not see on the list? Great. So I will list the names of the individuals who are absent today. Lucinda Carpenter, Conrad Reynoldson, John Safarli, and Aaron With. I believe I've covered everyone. Great. So we do have a quorum present. Thank you for the committee members, and we will proceed with the meeting. Also present, commission staff for Perry, civil rights analyst, and Angelica Trevino, our support specialist, and we are very grateful for their hard work and diligence and keeping us online and in order. The U.S. Commission on Civil Rights is an independent bipartisan agency of the federal government charged with studying discrimination or denial of equal protection of the laws because of race, color, religion, sex, age, disability, or national origin, or in the administration of justice. In each of the 50 states and the District of Columbia, an advisory committee to the commission has been established, and they are made up of responsible persons who serve without compensation to advise the commission on relevant information concerning their respective states. Today, our purpose is to hear testimony regarding potential barriers to accountability for police excessive use of force. And I'll note that this is our 5th panel in our series of this discussion. Today's meeting will also include a period for public comment later on in the agenda, and we will have an opportunity for members of the public to share their perspectives and opinions. If you are a member of the public joining online, commission staff will be messaging you to see if you would like to comment. Please keep an eye on your chat box. For the members of the public who are joined on the phone with audio only, you'll be able to indicate with your keypad when we reach the point in the agenda if you would like to make a comment as well. At the onset, I want to remind everyone present of the ground rules. This is a public meeting open to the media and the general public. I want to remind everyone that this meeting will be transcribed from a recording for the public record. I ask that you please state your name when speaking. Panelists should limit their initial remarks to 10 minutes. After all the panelists have spoken, advisory committee members will have the opportunity to ask questions. In addition, written statements may be submitted to Brooke Perry at bperry@usccr.gov by July 22nd, 2021. Brooke, I don't know if I read that quickly, if there's a way to include your email in the chat for those public members if they needed another review of your email. Through some of the statements made today might be controversial. We want to ensure that all invited guests feel welcome and do not defame or degrade any person or any organization. As the acting chair of today's meeting, I reserve the privilege to cut short any statement that defame, degrade, or do not pertain to the issue at hand. Any persons or organization that feel defamed or degraded by statements made in these proceedings should contact our staff during the meeting so that we can provide a chance for public response. Alternatively, such persons or organizations can file written statements for inclusions in the proceedings. I urge all persons making presentations to be judicious in their statements. The advisory committee appreciates the willingness of all participants to share their views and experiences with this committee. I would now like to begin our meeting by formally introducing our today's panelists and thank them for their participation. We look forward to hearing from them. Bios have been sent around, so I'll do brief introductions. We are joined by James Bible with the James Bible Law Group, and Tim Burgess, the former president of the City Council and interim mayor of the City of Seattle in 2017. And before we have the individuals begin, I'll just do a quick review of the agenda so we have a good scope of timing. We are at the 3 o'clock to 3:05 hour of introductions, and we will hear from our panelists until around 3:25, 3:30. And after which we will have question and answers from the members of the committee. So with that, I will turn it over to our esteemed members who will be speaking to us today. And James Bible, if you could begin, and thank you for joining us. I think you're on mute. That sticky mute button.
I could be saying all kinds of things right now. No. So if anybody felt defamed, it was probably in what you couldn't hear at that moment. So let's do the 10 minutes. Is that where we are?
Yes.
Okay, so I'm at like 9:45.
We'll give you 15 seconds back.
15 seconds. Thank you for the 15 seconds. I would ask that they be taken from Tim Burgess. I'm kidding, Tim. Okay. I've known Tim for a long time, like so many other council members and people that have been interested in justice, that have actually stepped into the arena. And we haven't always agreed. Sometimes we have. But it is nice to be here with him at this moment. Our systems of justice that we have in our society sometimes create more of an illusion of fairness than actual fairness. Much of my practice has been dedicated to achieving what I think is actual fairness and breaking down systems in such a way where we can be in a place where we live up to our Constitution and what we say are our stated ideals in terms of all people being treated equally, in terms of human rights and civil rights actually applying here. Sometimes that's a struggle. Over the course of the past 15 to 20 years, I've represented individuals such as Shay Taylor, who was shot and killed by Seattle police officers while following instructions. My Chance Gittens Dunlap, who was shot and killed in a botched sting operation where he was not the suspect, but was shot several times and killed. He was just 17 years old. Sean Furr, who was shot in the head while holding his baby just a year ago. And Manuel Ellis, who was walking home after church with donuts in hand when he was stopped by police officers and thrown to the ground, beaten, choked, tased, hogtied. And as he was saying, "I can't breathe, sir," which is what was captured in a Ring video. "I can't breathe, sir." Those were his actual words. As an officer said, "Shut the F up" to him, and then put a spit mask over his head. Now that's not defamatory, it's actually actual fact. It's on recording, and criminal charges have since been filed by the Washington State Attorney General's office in relation to that particular case. But our system of justice in terms of accountability and police conduct break down in part because we as a society don't tend to hold our officers as accountable as we should hold them. Sometimes municipalities are in a place where they're negotiating away their ability to actually protect civil rights of those that find themselves within those borders. And it can be heartbreaking, not just on the macro social level, but on the micro social level as well, the individual level. The reality is that we found millions of people in the streets last year marching, chanting, asking for redress from our government, not just because of single instances, but because of a multitude of instances. And not just the multitude of instances that we actually know about, but some of the regular day in, day out degradations that occur to people of color in terms of getting thrown up against walls for no real apparent reason or stopped, children being stopped while heading to school and being told that they've done something wrong. Those sorts of things resonate with us. And I'm hopeful I'm hopeful that with what we saw last year, some good can come, some actual authentic change. But I hope that we don't stay at the surface and treat these as isolated, horrific instances when there are these daily degradations that adversely impact our ability to achieve justice and true authentic opportunity here. So I'm happy to join in on this conversation and more than willing to share what I think. And now you are on mute, sir.
There we go. I'm tripping over. I thanked you, and thank you for your comments. We look forward to hearing from you during the question and answer, and thank you for your commitment to doing what you do. And with that, I will pass it over to, I'm not sure which title to say, former mayor, former city council chair, but Mr. Tim Burgess.
Tim is great. Good afternoon, members of the advisory committee. Thank you for inviting me to be here. James, it's good to see you again. And Eric, I think it's been 20 years since I saw you last, but you look good. As Brian mentioned, I'm the former president of the Seattle City Council. I was first elected citywide in 2007 and then re-elected in 2011 and 2015. In 2017, I served as the interim mayor of Seattle following the resignation of the previous mayor. I'm also a former Seattle police officer and detective. Policing today, as you all know, is not easy. And I understand that our officers are sometimes asked to resolve conflicts that society in general has failed to address. I know that officers often face dangerous circumstances, sometimes requiring almost instant decisions. It's a tough job. And I honor and support those police officers who serve with distinction every day, every shift, all across the state of Washington. Police effectiveness in the communities they serve is tied directly to how the public views their legitimacy. And this is especially true in communities of color with a long history of race-based inequities and misconduct by police. Here in our state and across the country, we have roadblocks, systemic roadblocks, that cause the public to mistrust the police and question their legitimacy. One of those roadblocks, and in my opinion, one of the most damaging in terms of public trust and confidence in the police, is the widespread use of private arbitration to resolve disputes related to officer accountability. Here in Washington, and as I said, this is true across the United States, it is not uncommon for private arbitrators to find that misconduct occurred, but then rule that the punishment was too harsh, thereby substituting their judgment for that of the police chief or sheriff. The very managers who impose discipline and who are responsible for creating a culture of professionalism, of fairness, of constitutional policing within their organization. These private arbitration reversals after findings that misconduct occurred undermine the police leader's authority and make it extremely difficult to change police behavior and change the culture of policing. Every time a dismissed officer is ordered to be rehired, the message that is communicated to other police officers is, quite frankly, you can get away with almost anything. We had a case just like this in 2014 in Seattle. A Seattle police officer entered the back seat of a police vehicle and punched an already handcuffed woman in the head, breaking her eye socket. The police chief at the time, Kathleen O'Toole, after the internal investigation, fired the officer for excessive use of force. The officer then used his option to appeal his dismissal to a private arbitrator. After hearing the case, the arbitrator agreed with Chief O'Toole and ruled that the officer used excessive force, but then inexplicitly ordered the officer's reinstatement. Arbitrators often split the baby like this to win favor with both sides, to secure future business. The incentives surrounding private arbitration are wrongly placed. These private appeals, these secret appeals, destroy public confidence. A recent national study of private arbitrations in police misconduct cases found that terminated officers were ordered reinstated by private arbitrators in 46% of the cases, almost half of the cases. If you haven't already, I encourage you to read this study. The cases where terminated officers were ordered rehired involved excessive use of force causing death, life-threatening physical injuries, perjury while giving sworn testimony, lying on incident reports, and lying during internal investigations. And these reversals are not because of procedural due process errors. They are often simply the arbitrator disagreeing with the police manager over the discipline that was imposed. Police officers certainly deserve appeal rights, as all public employees do. But those appeals should be open to public scrutiny, be limited to the facts used by the police manager in reaching their decision, and be guided by a consistent burden of proof standard. Our current system that allows for private arbitration blocks any chance for an effective, transparent, and legitimacy building process. Finally, as I close, I would also observe that police accountability standards and procedures should not be subject to collective bargaining. Not for public servants, we grant the power of arrest and the use of deadly force. Professor Benjamin Sachs at Harvard Law School, regarded as one of our country's leading labor law scholars, and the former Assistant General Counsel of the Service Employees International Union, agrees. Professor Sachs believes that state statutes should be amended to limit the subjects of police collective bargaining to pay, benefits, and work hours, so that accountability standards and processes are no longer subject to negotiation. Your committee, the Advisory Commission here in Washington, can make recommendations to the National Commission that can enhance police accountability, build public trust, and very importantly, honor the police officers who serve with distinction every day. I believe the people of Washington want that kind of policing that is effective, fair, respectful, and entirely consistent with the Constitution. I'm happy to address any questions.
Thank you, Tim. And again, thank you for your service and for your comments. Before we answer, a quick note, I'd like for the record to note that Conrad Renelson did join during the testimony period. And so I would like to note that he is participating. He's a member of the committee. And with that, I'd like to open it up to the discussion to the committee. Members present to ask questions of our panelists. I'll address each committee member in roll call style so that each member will have an opportunity to ask one question and a follow-up. Please wait for your name to be called before asking a question. If time allows, additional questions will be permitted. In the event that there is time for additional questions, please use the raise your hand function to indicate that you would like to speak, and I will call on you to address the panelists. So thank you for your testimonies. And with that, I will use the alphabetical order of those panelists who are joining us, for the committee members who are joining us. And Kim Ambrose, do you have questions you'd like to ask?
Sure. Thank you so much. Thank you, James. Thank you, Tim. We really appreciate your time and your expertise here today. James, for you, as I was listening to Tim talk about the arbitration and the issues around discipline. I know that what you do is you're seeking redress for your clients in various ways, right? Your clients who've been terribly harmed. How do you think that the disciplinary processes, do they affect your clients? I mean, after the case, are these issues that come up for your clients as they're experiencing the family members of folks who've been injured or folks who've been injured? Does the disciplinary process matter to them? And in what ways have you seen that matter? And what are your thoughts about that? Muted.
Got it. All right. So the disciplinary process is critical to my clients. They want some form of acknowledgement from the system that something will actually be done that led to whatever harm was committed to them or a loved one. I can remember a lawsuit that I filed with the King County Sheriff's Office, and one of the first things that the sheriff at the time did, who's now the Susan Rohr, did that was really powerful was during mediation, she walked into the room and told my client, who was a young African American male with cornrows, who was working 14 hours a day and doing the very best that he could, and was actually a victim of a crime when he got beat up on tape by police, that she was so sorry and that she promised this would never happen again and that she would actually do something about it. And he stayed very strong for 13 months in relation to all that, but that moment brought tears to his eyes. And he said thank you to her for that. And it definitely changed a lot in terms of his outlook. For the parents and the children of those that have lost their lives as a result of police violence, they absolutely want accountability. They want the system to put officers in check when there's a wrongful death. And they want something more than a check. They're often disappointed when somebody isn't removed from their job and or in a place where they have criminal charges filed against them. But when criminal charges aren't filed, and then when the person isn't fired, but a significant settlement comes through, they do wonder, well, how come that person wasn't fired? If I shot somebody on the job in that sort of way, I would be removed. And the reality is that it is because of arbitration. It is because of negotiation with the union at contract time and things that I think are constitutionally questionable being put in the contract negotiations that it needs to stop as void against public policy.
Thank you.
Kim, did you have a question for Tim Burgess too? Sure.
Oh, I get to ask. Oh, I thought maybe I only just got one question. Tim, thank you. And I think you addressed a lot in your statement. I really appreciate it. And in the end, you suggested that there was legislation that would be required or that could help. Does that have to take place at the state level, or are there things that local jurisdictions could also do that might resolve some of the issues that you saw in the arbitration process and or the bargaining process?
Here in Washington state, it would have to be at the state level. Cities, subdivisions of the state, cities, counties, etc., can't do things that are contrary to Washington law, and the right of private arbitration is built in state law. So that would have to be changed there. The legislature made some changes this last legislative session to arbitration as it relates to how arbitrators are selected. That's a step in the right direction, but there are many, many more steps that are needed.
Well, if I could just follow up on that, what about like a city council's ability to just be better at negotiating? I mean, I've been following like in Spokane where they just refuse to sign the contract, or even in Seattle where it's taken months or years to get a contract because the council refuses to approve of certain contract provisions. Is there any teeth to that approach at all? Like a city council that could just really get hard on the union and on those particular provisions, particularly where they are trying to bargain away disciplinary procedures?
So I can't comment on Spokane. I don't know that situation. In Seattle, the executive or the mayor is responsible for negotiations. We have a process, or excuse me, I'm not there anymore. They have a process that has a joint labor committee that has representatives from the city council and from the mayor's side. Those sessions basically establish the broad parameters of negotiations, but the actual negotiations, the sitting with the union representatives and such, is done by the executive side. When a contract is negotiated and it's brought to the city council for either approval or rejection, there are a host of legal issues there that I probably would be inappropriate for me to talk about. I mean, it basically, the city council's hands at that point are somewhat tied as to whether or not they could reject a contract that had been negotiated. So I'll leave it at that.
Thanks.
Thank you. Tony Begangus in West Richland. Do you have any questions for either panelist?
West Seattle, I kind of like that.
I'm sorry.
That's okay.
West Richmond, the fine West Richmond.
Not enough coffee for you. Okay. This is kind of to, you guys, thank you, first of all. Every time we have one of these, I've learned something. And it's always something that's, wow, if only I knew it. I was a councilman for 8 years. So, Tim, brother, I'm with you. So, Mr. Bible, you know, one of the things we hear a lot about is qualified immunity being a big factor. And is it really, is this really simply more of a case of, can we just provide language for cities, say, hey, use this language in your bargaining agreement, and we got it covered? Or is this a case like Mr. Burgess said, where, hey, the right of a private arbitration is built in? Sorry. So can you enlighten me anyway on what have you seen on that?
So my perception of qualified immunity is that it's am I on mute again? No,
You're good. You're good.
Okay, my perception of qualified immunity is that it really impacts things on the civil level. It's a way in which defendants are sometimes able to get charges dismissed without them being heard by a jury. It certainly is a problem in terms of accountability for departments and individual officers and municipalities. But I don't necessarily think that it precludes those offending officers from being charged with crimes in the way that some people sometimes believe that it does. It's a civil protection, really, is how I would look at it. It's a civil protection that needs to go away, because I think that the people actually need to hear these cases, make a decision for themselves. Ultimately, I believe that they're capable. So it's different than what most think.
So is there a way we could address it, or does it need fixing? Is it too broad?
Well, I don't think that qualified immunity should exist. I think that it should be heard by cases should be heard by juries or by the what's called the traditional summary judgment standards, in terms of even if everything is true, the case should still be dismissed, and then a judge can make a decision on that level, as opposed to saying, well, you're granted qualified immunity from the civil suit. At the state level, qualified immunity is something that us litigators talk about addressing there on a regular basis. On the municipality level, and frankly, your insurance companies would probably have something to say about this, but all municipalities have decisions to make about whether or not they exercise qualified immunity as a legal strategy. But then again, I think that your insurance companies would probably step in and say, well, we're not going to pay for whatever happens if you don't make these particular motions first. So we see that as a reality. But yes, qualified immunity does need to go.
Can I have a follow-up question with Mr. Burgess, Brian?
Absolutely.
Okay, thank you so much. Kind of following up a little bit about what you said earlier. Cities bargain things away. I've been in that position where here's a package presented to you. Okay, can't ask a lot of questions. That's the way it is. It is done in secret. Is it really, can we just solve the problem, a lot of it, by just saying, here's some standard language that you should use in your bargaining agreements that protect people's civil rights and take away this arbitration thing that's used maybe badly in some cases?
Well, specifically on the arbitration issue, I don't think any union in negotiations is going to give that up. There was attempt in this last legislative session to significantly change arbitration, and the police unions were opposed, but so were all of the other public employee unions. And I think they fear that if we make an exception for police officers and their contracts, that it's kind of the camel in the nose, the camel's nose in the tent, and the legislature will want to do firefighters next and electrical linemen and road crews next. So there was universal opposition to significant changes in the arbitration law of our state.
Next question, David DeWolf. Do you have questions for the panelists?
Yeah, it's very interesting that we have two different kinds of deterrence systems represented here. One is the civil side, where a police officer's misconduct will lead to a judgment against the municipality or the city, and that's bad, and so it encourages the police department to develop procedures and training and selection processes that reduce the likelihood of police misconduct. But the other process that Tim Burgess was talking about was the holding individual police officers accountable through either loss of job or in some cases criminal prosecution. I'd be curious to know how you see those two systems working. Are they in parallel? Do they conflict with each other? Is one preferable to the other? How do you see those two systems interacting as a way of reducing police misconduct? And I'll start with Tim Burgess, and then if James Bible could comment, that would be great.
Thank you, David. So there's actually three systems to hold police officers accountable. There's the internal administrative discipline process, where police chiefs and sheriffs can discipline officers who have engaged in misconduct, all the way from relatively insignificant or minor things to very serious misconduct. So that's one system. The second system is the criminal side of our laws, where police officers can be charged with crimes. That in the use of deadly force, anyway, in Washington state, that used to be essentially impossible because of the state statute that required a burden of proof on the prosecutor that was essentially impossible to meet. That was changed because of the Citizen Initiative 940 that changed that law. So that's the second way, is by charging police officers with a crime. And the third way is the civil side that James is involved in. And I would argue that all three are needed. They all play a unique role. They're kind of related in some ways, but yeah, all three of those are needed.
Thank you.
In terms of deterrence, I think that it's critical that police officers that violate the law have a healthy fear that they could be criminally prosecuted. My clients often are in a place where they would prefer criminal prosecution over anything else. Sometimes they are left with nothing but civil litigation and the opportunity to maybe change some laws. Our focus in terms of our wrongful death cases is always in putting pressure on departments and the powers that be to push for prosecution, to push for public knowledge, to push for potential changes in the law, and also to do the civil litigation that sometimes is necessary in terms of having any opportunity to achieve any amount of justice for my clients. I think that they're all, just as Tim said, important tools to use for accountability. I think that the criminal prosecution tool is not used often enough in terms of police conduct.
Thank you.
Thank you, David. Judy, Judy Indigent, do you have questions?
I do, and I don't know why I think I'm echoing because I hear twice.
I think you're calling twice, but if you mute one of the two or hang up one of the two, I think we'll be able to hear you. All right, Judy, why don't we move on? I promise you'll be next as soon as you get on there. How about Andrew Kaufman? Is Andrew available?
Sure, yes.
Thank you.
Yeah, I have a question for Tim Burgess. Ask you to play devil's advocate for a second. What do you think is the best argument for the private arbitration system for police officers? And how would you respond to that?
Well, I don't think there's a good argument for private arbitration. I would change that system. I strongly believe that public employees, including police officers, need appeal rights. In case there's errors made or in case their due process rights were violated. So I have no problem with them having appeal options. I would send those, though, either to a city's public safety civil service commission, or in Washington state, we could use our administrative law judge system to do those, so that we would truly have independent, objective arbitrators who would not necessarily rely on this for income, trying to split the baby to make sure that all sides want to rehire them again, but instead administrative law judges who are paid full-time by the state and are in place to handle cases just like this. That would, in my view, be a better way to allow for arbitration.
Thank you.
Let me just say one more thing about, sorry, Brian, if I could just say one more thing about that. You think about a police officer who is engaged in misconduct. So we're already past the point where their police manager, the chief or the sheriff, whoever it is, has already made a judgment that they committed serious misconduct and they're going to be fired. But then they go through this private secret arbitration process, and a few months later, they're rehired because the arbitrator said, nah, the punishment's too strong, or I just disagree with the punishment. It's kind of, it just wipes out any credibility that the internal discipline, the administrative internal discipline process has credibility. And I think that's, and I wish, and I've told the police unions this, I wish they would recognize that it makes it even more difficult for police officers to do their jobs effectively when you have a system like that.
Thank you, Tim. Judy, are you there?
I'm here, and I can't figure out how to get rid of myself. Yeah.
One second. Let me try that.
Okay, which is practically, how do you think we can get over the union's opposition to any legislation that seems to be necessary in order for us to fix the problem described by Tim?
Well, it's going to be very difficult, and that's why I think it's going to need a change in state law and public pressure, public awareness on the issue can change opinions in Olympia. We've seen that on many subjects. I think we also have to be very careful that we don't act in a way that in fact makes the appeal process unfair for police officers. For example, some have suggested that appeals should be held in a public forum, and that's just untenable. It would not work. It would not be effective, and it wouldn't be fair to police officers. So something short of that, like using administrative law judges, would be much better. And it's going to take time to persuade the legislature to make those changes.
Thank you. Thank you, Judy. Hopefully, you have a follow-up question? You're on mute. If not, we'll come back. I'll ask you eventually. Xanthi Meter, do you have questions for the panelists?
Yes, thank you, Brian.
Yes.
Thank you both, Mr. Burgess and Mr. Bible, for being with us today. My question is for Mr. Bible, and it's kind of a two-parter. Why do you think the costs of civil suits have not been as effective in police reform, and how might they become more effective?
I'm sorry, did you say the costs?
Yeah, I mean, so I'm thinking about the costs to the city, you know, and taxpayers, really. Like, on one hand, well, and I guess on one hand, I would say, as a citizen, that would infuriate me and make me want to apply pressure. But why do you think that the costs of civil litigation against police officers hasn't been super effective in police reform or holding cities accountable, or police accountable?
Well, I do think that there's actually been an impact behind civil litigation. When there are settlements, there are a whole host of things that actually occur. Then the city has to go back and there's retraining and there's conversation about what happened, what went wrong. More importantly, the cases need to be publicly known and there needs to be public exposure. One of the things that I think is really important to understand is that over time, people learned that the greatest deterrent to domestic violence was not just a criminal charge, but also your neighbors knowing about you to some extent actually created a significant deterrent. So if your neighbors had the idea and understood that you had beat your wife, then that had more of a deterrent than the actual criminal charge itself. The same thing may be true in terms of civil litigation. We want to make sure that these things aren't done in silence, that the settlements aren't behind closed doors with large sums of money, but in the public so that we can start unpacking what our system looks like. I think one of the powerful things that's happened with the Manuel Ellis case is that everything was very public and very known. And as a result, a lot of laws were challenged in the state of Washington at the legislative level. The city of Tacoma finally did get their body cameras that they had talked about getting for several years, but never actually put into place. And I think that that's all a part of an active campaign. So I think that when you do civil litigation in this realm, you shouldn't be prepared to do it in silence. You should be prepared to do it authentically in public, where you're challenging ideas and forcing people to say what they think and feel. I think that was also the power of the George Floyd litigation. The money certainly is an issue in terms of what they had to pay out, but what was more important, I think, to the city was what became known, right? So we need to make sure that people know and it's not a secret.
Thank you.
Thank you. You know, in Mr. Ellis's case, James is right that we finally learned about that case, but it was only because different people investigated that case. If it had remained where it started, we might not know much at all, except for what James is trying to prove with his, I assume you have a relationship there, an attorney-client relationship. So
Right.
working for his client, he might have been able to discover things. But what really opened that case was that others stepped in, the governor, for example, in ordering a different investigation. And that's why it's important that all of these things be open for public scrutiny. So we can praise those who do a good job investigating these cases, and we can hold accountable people who don't do a good job.
Right.
Thank you. Thank you, Santhi. Conrad Reynoldson, do you have questions?
Yes, thank you. And I appreciate both of our panelists today and hearing all of their thoughts. It's been enlightening and educational as always. And so a question that I have asked previous panels, and I think would be good to find out from this one as well, would be if you could wave a magic wand and immediately, and this is regardless of the likelihood of actually passing the legislation necessarily, but attacking something legislatively or otherwise, if you could implement one discrete action item or reform that's really been discussed either in this panel or more generally, what would you choose and why?
So I always get nervous behind magic wands because the reality is I don't think that there is necessarily any quick fix, and just when you think you have one, something else pops up and you have to change it. But if there was something that I would want to immediately happen here, it would be the authentic creation of an independent agency that actually investigates governmental conduct, which would include police conduct. It has subpoena power and the ability to prosecute individuals criminally. Other states have that. I think that it would have a powerful impact and take some of the power away from local prosecutors that have authentic relationships with law enforcement that may impact their ability to actually prosecute them. So that would be, I guess, what I would use with my magic wand, knowing that there would be a whole host of things that would probably have to change right after that.
So as it relates to police accountability, I would want the legislature to pass a set of laws that first removed police discipline and accountability process, procedures, and rules from collective bargaining. And I would set those processes and rules in a new statewide system. So it would be the same all over the state of Washington, regardless of whether you worked for a local police agency or a county sheriff or whomever. Right now, we have literally dozens and dozens of different accountability standards spread across the state of Washington because they're all subject to collective bargaining. Second thing I would do is I would require that in the appeal process, whoever is going to be the final judge of whether or not the discipline imposed was fair and appropriate, I would require through a state statute that there be a uniform standard of review. So how are we going to assess whether this was right or wrong? And everyone in that seat would have to use the same standard of review. And if new evidence is presented, rather than the arbitrator or the administrative law judge hearing that evidence and then making a judgment, they would merely send the case back to the police manager, the chief or the sheriff, to investigate further and then decide, do I stick with the decision I made or do I change it because of this new evidence? Right now in arbitration, we have on occasion where new evidence is brought to the arbitrator. The investigation is finished. It may have lasted several months. The police chief or sheriff has made their judgment. Now the officer is appealing in arbitration, and oh, guess what? I found new evidence that's exculpatory, and you should hear this case de novo. You should hear it from beginning to end with this new evidence. That also undermines the authority of the police chief or the sheriff. And so if that happens, if new evidence is presented, then the arbitrator or the administrative law judge should have to send that back for further investigation and a new determination. Maybe it's the same, but maybe it changes. So I would do those things. I would also, and I think Washington is going to do this one, I would set a statewide use of force standard so that it's uniform across the state of Washington. And I would require, as the legislature just did, that discipline be mandatorily reported to the state so that there is a database of all discipline cases on officers.
Thank you. Eric Schnapper, do you have questions?
Yes, thank you. First of all, let me thank both Tim Burgess, who I've not seen for some time, and James Bible, who I've not had a chance to meet before, for coming today and for sharing your wisdom about these matters. Before I get to the question, I'd like to just make a request to both of our panelists. It rises out of something that Mr. Burgess said about the large number of issues and how much the devil is in the details. Mr. Burgess, you've identified, I think, at least two specific things about the way arbitration works that you think should be changed. And as you noted, same issues are going to come up if we have an administrative law judge. So I'd just like you to both to mull this over some more. If you have any other specific ideas about safeguards we need to keep an arbitration process from interfering with the ability of chiefs or sheriffs to comply with the Constitution, to give us a supplemental statement about that, because I think the details of this are going to be really important. So first of all, for Mr. Burgess, as you noticed, when there's a proposal for the legislature to take police wholesale out of the collective bargaining process, or big chunks of it, there was a great deal of pushback from organized labor. I'm wondering whether it would be a constructive step for the legislature to proceed in a smaller step and impose safeguards with regard to the use of force specifically, rather than trying to get into all disciplinary matters and move everything and reform arbitration as to everything, and just to reform it as to the use of force, which I think is what's been particularly concerned to this committee, and I think to the witnesses that we've heard from. Because I think that seems to me that's going to draw less fire. That could apply to everybody. If a firefighter uses force, anybody using force, we'd have a rule, but it would be limited to that and would have that specific, as you said, constitutional basis that just wouldn't bleed over into other things. Would that be helpful, or do we need to move the police out of, move everything the police do out of collective bargaining?
Well, I do not favor eliminating collective bargaining for police. I think they should be able to engage in collective bargaining, except for the terms of discipline and the process to be followed for discipline. Your suggestion, Eric, to just deal with use of force cases where there's been excessive use of force and therefore misconduct, that's been suggested by others, that that would be an incremental step, probably in the right direction. But then it raises a second question, which is, well, what about perjury? What about dishonesty? What about other egregious forms of misconduct that unfortunately sometimes happen? Do those become lesser offenses because they're not included in that use of force? And so that's worth a lot of discussion, and probably smarter people than me dealing with that. But I would hate to create the impression that other misconduct is less significant. You know, in policing, there are mistakes and there's misconduct. And it's very important to understand that and separate those. As a young patrol officer, I made mistakes, but it wasn't misconduct. And so it's very important for police leaders and for police officers to know that it's okay to admit you made a mistake, and you can get further training, or you can get whatever is necessary so that that doesn't keep happening. That's very different from misconduct. And so I think if we have that frame of reference, we'll do a lot better in how we proceed going forward.
Thank you. Mr. Bible, do you have any particular thoughts about aspects of this arbitration system that you think would need to be changed?
Well, ultimately, I think that it should be scrapped in relation to whether or not an individual officer has violated civil or human rights. That's at the heart of the issue for me in relation to policing. In terms of misrepresenting information, lying, doing those sorts of things, I think that it's important to address. But I also think that there are other tools for that, including making it so that they can't be used in terms of as witnesses, witness stands by prosecutors, because they have questions or problems in relation to honesty that would then impact their ability to maintain their job as a police officer or to be on the beat, so to speak. But in terms of civil rights violations, human rights violations, I don't think that those sorts of issues should be subject to arbitration. I feel like you should be able to be fired via your civil rights violation through a different form of administrative process. And maybe at the end you go to a jury and it's public and they decide. But it's something that would have to be evaluated differently.
Thank you.
Thank you. Well, I just happen to be the last person alphabetically on the panel, so I'm going to ask questions and then we will wrap up the panelists unless we have a little bit more time. Two questions, Mr. Bible, thank you. My question is more kind of a broad question. What are some of the systemic barriers, in your opinion, have prevented you, your clients, and many of the communities they come from changing the laws and giving them a voice both in Olympia, but within city halls and within police unions to make the kind of changes that are necessary to protect their lives and give them the fairness and diligence they deserve from the law?
Well, sadly, under our current democracy, money and power is the biggest obstacle in the way of the people being able to actually exercise anything that leads to change at a legislative level. I think that's a harsh reality here that we need to address. The other thing when it comes to accountability systems and policing is reality that the unions are strong and that the perceptions are stronger. Perceptions of people of color and what they do or don't do, people in poverty in relation to what they do or don't do, people that have mental health issues in terms of what they do or don't do that may lead them into conduct or activities with police officers that lead to civil rights type violations sometimes. So in the back of a lot of folks' minds, you have this belief that, well, they interacted with law enforcement in a particular way that led to that outcome. So there's already that internal bias that impacts changes in the law because of the perception of who is asking for redress. And then there's the power of the individual law enforcement agencies themselves, and the reality that a small percentage of individuals that break the law with impunity that are actual police officers hide behind the hundreds of quote unquote good ones and are able to move through in such a way that the policing system right now is so busy protecting them because they're afraid that they will lose legitimacy in the eyes of the public. When I think that ultimately they would gain more legitimacy by pulling those bad actors out and saying, you can't be amongst or with us. In the legal realm, we have the Bar Association. And the Bar Association will sanction attorneys because you as an attorney make the rest of us look bad and untrustable. Totally different in law enforcement. That's not being done. We'll protect you because we don't want to be in a place where there's any questions about the rest of us.
Yeah, thank you. Mr. Burgess, from a city council perspective or a city leader perspective, as part of the collective bargaining agreement, are there steps that mayors and city councils can take around the state to be proactive about the kinds of police forces that we change into, incentivizing more police forces to reflect the communities they police, the lived experience, incentivizing the notion that our police are guardians, not warriors going into communities? Are there mechanisms and levers that mayors and city councils have as part of this collective bargaining agreement, which I think goes to the core of behavior and the kinds of individuals we attract to the police force?
Sure. And not necessarily related to collective bargaining, although that's important. But, you know, many of us have advocated for some time that the age of entry of police officers should be higher than age 21. We know that the human brain is not really capable of independent, objective decisions until about age 24 or 25. So we ought to look at that and make a judgment about how old police officers have to be when they enter the police service. Same could be said for education. There's not much literature on this because it hasn't been studied that much, but there are a few studies that indicate that police officers with a college degree use force less often. We do know for police supervisors, the frontline supervisors, sergeants and lieutenants who have a college degree use force significantly less than other frontline supervisors who don't have a college degree. Cities and counties could incentivize current police officers to go back and get their bachelor's degree if they don't have one. There's a lot we could do to make policing both more effective in protecting people and communities, neighborhoods, and raising the standards for the quality of policing that we have and whether or not it meets our constitutional principles, which are quite high in this country. And that's a good thing. People like James and other attorneys try to keep people honest about that. But I think, yes, city leaders, mayors, city councils could do a lot more to dramatically change law enforcement in our state and in our country.
Thank you. We have about we have literally 7 minutes if we're sticking to the schedule. Are there any other questions from the committee for the panelists? Brooke.
Yeah, if the committee would allow me to ask a question. Great. So we've talked a lot today about barriers to accountability that happen after an initial discipline decision is made about an officer. In both of your different perspectives, do you think local departments are doing a good job of making discipline decisions and holding officers accountable, both from individual officers who are doing misconduct and addressing disparities that are happening in the way use of force is used?
Well, I can only really talk about Seattle. I don't really know the background or the experiences of other police agencies. I think we do. We here at home in our city, we've made a ton of changes in the police accountability system. Nationally, our system gets talked about as probably the best in the country. And, it's this three-legged stool approach. We have the Inspector General, we have the Community Police Commission, and we have the Office of Police Accountability. People away from Seattle talk a lot about, boy, I wish we had Seattle's system of internal affairs and how we hold police officers accountable. So I think, yes, we've made good progress there. There's another issue in labor law and in state law that I think is a roadblock. And that is that if you have disciplined a police officer for a particular act, and now along comes another officer who does something similar, the discipline must be consistent. And I understand that at a certain level, so that you do not let bias or unfairness interfere in that process. But sometimes I wish that police chiefs would reset that standard and say to, which they can do in the law, they can announce to everybody who works, in this case for Seattle's police department, effective today, the standard is different. We're resetting everything. And those who argue for this argue for a matrix system to discipline. So if you commit this particular misconduct, here's the range of discipline you might receive, et cetera. Much like the sentencing guidelines that we have in the criminal courts. There can be exceptions, but generally you follow these general rules. So I think Seattle's done a good job. We can always do better. I wished we had more civilian investigators in the Office of Police Accountability. I know the director would like to have more civilians. That's limited by the collective bargaining agreement. Another reason why it should not be subject to collective bargaining for those reasons. But we've done well, and we could do better.
I think that realistically, there's very little incentive on behalf of police departments to actually expose misconduct. I think that that's a harsh reality, and as a result, on a lot of levels, departments spend more time seeking to hide it than to expose and deal with it, along with rank and file officers, sergeants, and the like. The reality is that's a statewide issue. I would tell you that right now, given how much I've dealt with the city of Tacoma and its police department and the Pierce County Sheriff's Office, I'm shocked, utterly shocked that they haven't been taken over by the Department of Justice, because there really are almost no systems of accountability in their system. They fight things remarkably hard. As some of you may have seen, a Tacoma police officer even ran over a group of people, and his own son wrote an article about why his dad should actually face some amount of sanction. And I can tell you that he hasn't, even though it's been on video. Just as that it took so much work to expose what happened with Manny Ellis, which started out as a situation where 7 or 8 dedicated civilians actually assisted us in investigating the case and collecting information in relation to witnesses and helping us get those witnesses on film and getting those actual recordings was really critical. But the department took no steps to do that whatsoever. So I think that speaks to the lack of incentive. The hope is for a lot of departments is that they'll get some sort of legitimacy and maintain it without actually doing the very tough accountability work that frankly the departments need to do, because they should be best situated to actually do it. At the time that we were investigating the Manny Ellis matter, the city of Tacoma Police Department and their union was writing a letter writing about how the actions of the officers in Minnesota were deplorable, but that you can trust that that's not Tacoma. Well, we learned something different, but that letter was to protect image over authentic accountability, and that's the problem we have.
In Seattle, every misconduct case that results in a finding of misconduct is posted on the web. And so you can go to the Office of Police Accountability website at seattle.gov, OPA/OPA, and you can read all those cases. And I think the director there has done a superb job of addressing in part what James talked about, and there's much more vulnerability and admission of what's going on inside the department. I'm not sure that's the case around the state of Washington.
I'd say it's definitely not the case around the state.
Thank you both.
Thank you, Brooke, for that. And we are at the time, I want to thank the panelists. We're at time for our the committee members' question and answer period. And I want to thank the committee members for their question. Very thoughtful and appreciative. We are now moving on to the public comment period. The floor is now open for public comment, as I noted. We ask speakers to adhere to the topic at hand. If speakers begin to veer away from this topic or begin discussing possibly important but unrelated topics, I will politely interrupt and ask them to refrain from doing so. Please note that the public comment period is not an opportunity to ask questions of the panelists, but rather an opportunity to express your concerns and opinions regarding racial disparities in policing in Washington State. I will now turn it over to Brooke Perry, who will be facilitating the public comments if you have any.
We have no members of the public present at this time.
Okay, thank you, Brooke. So that concludes our panel for today. I'll have some closing remarks. Thank you for the panelists, James and Tim. Thank you for your commitment to public service, to the insightfulness that you share. We walked away far more educated than we started the day. So thank you for your time. And thank you for all the members of the public who attended. The transcript and other materials will be available within 30 days following this meeting. If you provided your email address when you joined, we will send you follow-up information regarding how to access those materials. We will also notify you when the committee is meeting for the follow-up discussion when the report will be available. The record will remain open through June 22nd, 2001. That is today. I don't know if there's a specific time. If anyone...
It's actually July 22nd.
Oh, July 22nd. We have a month. If anyone would like to submit written comments, again, please send by email to Brooke Perry, and I will read it slowly in case people want to hear it. It's bperry@usccr.gov. And with that, we will adjourn for a 5-minute break before a short committee debrief. Again, thank you, panelists, and thank you.
Thank you.
Thank you.
Yeah, thank you so much, Tim and James. Thank you for your time.
Yeah, great conversation.
Thank you.
For the committee members, as a quick FYI, it is 4:13, which means that why don't we reconvene? How about we budget and go to, what did we say? I said 7 minutes. Do you want it 4:20? Is that good? All right, we'll start up in 7 minutes at 4:20. Okay, I think Brooke, we have a critical mass ready to go?
Yep, let's go ahead and get started on our debrief.
Great. So thank you for today's discussion. Gonna get people coming in.